Welcome to the learners. Today we are going to discuss another important subject that is called the Salient Features of the Consumer Protection Act 2019. We have so far recorded several lectures by taking into each and every parts of the Consumer Protection Act, like what are the important definitions, what is the Consumer Protection Council, what are the Consumer Dispute Resolution Commissions, what is the Central Consumer Protection Authority, what is mediation, what is product liability. On all these subjects we have made separate recordings also. However, from the examination point of view, sometimes the examiners they ask as a big questions for 20 marks or so, what are the salient features of the Consumer Protection Act. Keeping such type of questions and the demand and the purpose in mind, we have made this presentation before you. So this gives the complete gamut of the entire actual consent. To begin with, let us see what is the objectives of the Consumer Protection Act 2019. There is not much a difference with the objective of the Consumer Protection Act 1986 vis-a-vis that of the Act passed in the year 2019. So primarily the Act aims for the betterment of the interest of the consumers, and the primary objective is to protect the interest of the consumers in all aspects. And for this purpose, that is for the protection of interest of the consumer, the law provided for creation and establishment of various institutional mechanisms. They are known as national, state and district consumer protection councils for deciding the policy matter. One is this is the three-tier structure: National Consumer Protection Council at the national level, and at the state level it is called the District Consumer Protection Council, and the district level it is called District Consumer Protection Council. So primarily these are three-tier structure, and their primary job is to decide on policy matters related to the protection of the interest of the consumers. So that is one of the purpose and objectives. Now, there is another institutional mechanism created under the law, that is called the Central Consumer Protection Authorities under the Act, and their job is primarily to carry out or undertake investigation about violation of the consumer rights or deviation from the regulation provided by concerned regulatory bodies, or is there any offences are committed, any misleading advertisement is made to the public. Like on this, the investigation has to be made. Then for that purpose, the institutional mechanism called Central Consumer Protection Authorities has been created. And the third institutional mechanism provided under the law is establishment of national, state and district level consumer commissions for the purpose of settlement of the disputes. Again, we have the three-tier structure. At the national level, National Dispute Consumer Redressal Commission; at the national level, State Consumer Dispute Redressal Commission; and the district level, District Consumer Commission. So these are the three-tier mechanisms. So one is for the policy matter councils, second one for the investigation purpose, that is the authority, and the third for the settlement of the disputes about the commissions. These are the three mechanisms provided and the institutional mechanism provided in the Consumer Protection Act is concerned. And in addition to this, the law for the first time brought in the council, the mediation council, provided for the establishment of mediation council for the purpose of promoting mutual settlement among the bodies between the parties. Primarily keeping with the large number of pendency of cases before the court of law, the consumers are not getting required justice within a reasonable time. Therefore, the law provided for a mechanism to provide a platform for settlement of disputes by the parties themselves. So that's a new feature added in the 2019 Act is concerned vis-a-vis the 1986 Act is concerned. Then another interesting important new feature added under that Act 2019 was initiation of the product liability action against that product seller, product manufacturer or service provider. There was no provision available in the 1986 Act for initiation of product liability action against this type of manufacturer, producer, sellers and all, but this is a new initiation that has been included in the law. And another aspect is the offences and penalties. That is, the law as identify what constitute offences, what are the penalties to provided, and all these are clearly codified under the law is concerned. Though these are the broad objective of the Consumer Protection Act is concerned. Now we slowly move into what are the other things, salient features of the Act is concerned. What are the salient features? And the salient features are to provide informal, inexpensive and expeditious justice to the consumers who are affected by the practice adopted by the traders and the service providers. Then also to promote and further the rights of the consumers by establishing Consumer Protection Council at the national, state and district level. That's what we have discussed already, that for the purpose of promoting the rights of the consumer, policy is advisory bodies are created at the national level, state level and the district level. We will discuss about little later. Then also to establish 3-tier quasi-judicial machinery, about which I referred already, and this aspect I have already covered in the first slide itself. Now, what are the remedies available or provided under the Consumer Protection Act against the consumers whose rights are affected? Number one, the remedies provided are against the consumer provided for to the aggrieved consumers are: one is the remedy or relief against the defective goods sold or defective goods purchased by the consumer. Then deficiency in services, charging of excessive price, then adoption of unfair trade practices, then adoption of restrictive practices, then offer of hazardous goods for sale, and loss suffered on account of negligence of manufacturers, suppliers and the sellers. Let me take very briefly. Now, this is the remedy available to the aggrieved consumer who purchased the goods, presuming to be it's a good, assured that it is a quality good, but later on it turns out defective goods. So therefore, in such cases, there is remedies available in the Consumer Protection Act. The very common example is the sellers selling the old vehicle as a new vehicle, as a new brand one, by making necessary changes in the vehicle or necessary modification, addition, alteration and all. This is one of the common defect in the goods noticed by the consumers in various aspects. So the consumer have been deceived of. They have been given the assurance that they will be getting the new piece of goods, but at the time when they purchase the goods, it turns out to be the old goods only. So this is in such type of cases, when the old goods are sold in the form as a new brand item goods and it is proved to be otherwise, then the consumer can have relief against the seller of that goods or the producer or manufacturer or the trader also. Then deficiency in services. Again, the deficiency in services related to the several services like banking is a service, insurance is a service, electricity is a services, education is a service, medical service is a service, house and house construction is a service. Likewise, then transportation, air travel, railway travel by road, these are also covered under the services. Even our mobile operations, mobile instruments, all those things, computer related, all those things are covered under the services. So in the course of the availing the services, if the service provider fail to provide the required service as promised or assured, then there will be a deficient service. The consumer can have a claim or relief against the consumer is concerned. Very simple example I can give you. If you have the fixed deposit in the bank and the fixed deposit has matured and you have a right to get the maturity value of the fixed deposit on the date of the expiry of the complete period. Where you approach the bank, but the bank says that sorry, we cannot release the maturity value because you have some other we have some other claim against you, which is not related to this at all. So failure on the part of the bank to release the maturity value of the fixed deposit on the date of maturity definitely will amount to deficiency in service. Or locker, the jewels you kept in the locker, bank locker, but when you want to open the locker, found out the MTB. So there is a deficient service on the part of the bank concerned, because they promise that the jewel will be kept in the under safe locker and all. If there is a theft or whatever happens, if you lose your jewels from the lockers, then that amount of deficiency in service. Like insurance policies, like when the insurance policy they assured you on several things, at the time taking a policy, but when it comes to the payment at the time of maturity, we have to undergo a lot of harassment and hardships and also that is also a deficiency in service. Like there are different service and all, we have already discussed about this. Now another one is the charging of excess prices. Very often the traders, they charge price more than the price printed in the label or other fixed by the concerned authorities concerned. In such cases, the charging of excess price is definitely it's not permitted under the Consumer Protection Act. In such cases, we can approach the court, then definitely we get relief or repayment to the extent of not only the excess price paid, but also compensation in the form of cost of litigation and other things also. So levying excess price than the price determined or price quoted by the company or the dealer is concerned. Very often, there's the rate quoted by the company is different, the retail and trader and all. However, pricing is you have the right to know what is the price of the commodity. If they charge you more than the price printed on the price list, then you have a right of a claim under the Consumer Protection Act concerned. Then action against unfair trade practices. Unfair trade practices, again, it's a common prevalence practice followed by the traders. Trade practices which a fair trade practice means the trade practices which are permitted within the legal framework, within the regulation, rules and regulations. Unfair trade practice means a practice which is contrary to the provisions of the trade practices provided under the law. Therefore, it is to unfair trade practices. Say alluring the people to say purchase your commodity, or making the people to believe that the product is genuine, whereas it is not a genuine product. So they are indulging in an adulterated goods. Sale of the adulterated goods is one of the unfair trade practices, and also unfair trade practice added by the traders is definitely a cause of concern, and the relief is available under the Consumer Protection Act is concerned. Then also restrictive trade practice. Some traders, by joining hands, by oligopoly, part of a formation, they restrict the trade practice. They adopt the restrictive trade practices. Such practices, if it is going to be cause loss or injury to the consumers, definitely such a practice can be challenged. We can have a remedy before the court of law. Then again, offer of the hazardous goods for sale. Hazardous goods cannot be sold for the common man for a sale or consumption also. So if any person or any trader or a manufacturer, they sell the hazardous goods which is not good for the health of the common masses, if it is sold, then that is prohibited under the law. So we can have relief or remedy under the Consumer Protection Act is concerned. Then the loss relief available. Loss suffered on account of the negligence of manufacturers, suppliers and sellers. Sometimes because of the negligence of the manufacturers, suppliers and for example, in the case of perishable commodity, that there is a time period is given, say bread value period may be 4 to 5 days, or milk maximum 3 days, 4 days only. Likewise in the perishable commodities. But if they sell the product like bread and the milk beyond that expiry period provided under the label is concerned, then definitely it's a sheer negligence, or even it can come as a unfair trade practice also. It can also be treated as a sheer negligence on the part of the suppliers and sellers. They should tell the consumers, look here, these are the outdated products, so they should not keep it in the stall at all. If they keep it, then it will amount to negligence on that part. Then we can have a remedy against such type of seller if they sell the outdated commodities to and all. So these are the general remedies available under the Consumer Protection Act is concerned. Now, rights of the consumers concerned, we have 6 rights of consumers. The right to safety, the right to be informed that for the consumers, the right to choice, right to representation, right to redressal, then right to consumer education. These are the 6 rights. Right to safety refers to the product sold should be at the the safety standards must be preserved and maintained by the seller or the producer or the manufacturer. And the right to informed of the right, consumer the right to be informed. We talked about the price. The consumer has the right to be informed of the price, the quality, the quantity, the purity, the content. So we have the right to know whatever the contents, all those things, whether the product contains all the ingredients provided, prescribed by the regulatory authorities, and also we have the right to be informed on all those things and all. Right to choose, right to choice. That we should have the freedom to choose among various commodities of the different types of same commodity. There should not be any monopoly. The trader should not. Sometimes you go to the shop, they insist you, madam, this is the only product available, please take it. They will be having other as a commodity of the other brands also, but they have a tie-up arrangement with the seller or the trader. They will have an arrangement for taking a higher margin of commission, so they will not show the other related or the similar goods. They only insist continuously the buyer to purchase one particular brand only. So it is against the right of choice given to the consumers. If they adopt such type practices, definitely it will amount to unfair trade practice. Then right to representation. As a consumer, we have to represent in government bodies as an individual or NGOs also for enforcement of their consumer rights. We have the right to be represented in decision-making bodies. That's what the NGOs, consumer-related organizations, associate with the decision-making bodies of the government. The right to redressal, about which I referred about the district commissions, district consumer commission, state consumer commission, national consumer commission will be established primarily for the purpose of settlement of the disputes and providing redressal for the aggrieved consumers concerned. Then right to consumer education awareness. The awareness about the consumer, about their rights. The consumer should know about their rights. So that is another right of the consumer education. So these are the 6 rights of the consumer, which is elaborately provided in the Consumer Protection Act is concerned. Then ambit of the coverage, all suppliers in all these cases, all the suppliers of goods and services in all the private, public and corporate and cooperative sectors all are covered. Only there are some exemptions. If the goods is sold or the services provided is not as per the market rate, or it's not the adequate price as per the market rate, then perhaps we may not have that remedy from the concerned government bodies. In all cases, for example, a hospital which gives 100% free service to all the patients come to the hospital, and in the course of providing free service by the hospital, if some of the patients they undergo certain inconvenience, in such cases we may not be in a position to file a case under the Consumer Protection Act because the services are provided free of charge. So any service rendered free of charge or any goods sold substantially at the lower rate than the prescribed market rate, such cases may not be covered under the Consumer Protection Act. For example, the goods sold through the fair price shops where the prices are comparatively lower than the price fixed by in the market situation. So these type of things are concerned. Otherwise, leaving it apart, whether it's a public body or a private body or a corporate or a cooperative sector, they all are covered under the Consumer Protection Act is concerned. Now, the another important which is no bar on other remedies. The Consumer Protection, it is the additional facility, additional protection made available to the consumer. So it is a consumer can have remedy under the Consumer Protection Law in addition to other facilities available in other laws, and also the consumer means that the provisions of the Act are in addition to and not in derogation of the provisions of any other law, meaning thereby if the person has an enforcement of the civil right and the civil rights also infringes his consumer right, then he can have the remedy for the infringement of consumer rights and the Consumer Protection Law. In addition to that, he can have remedy for the enforcement of the civil right under the civil code, under the Civil Procedure Code also. Similarly, an employee who is having a workman who is covered under the Trade Union Act and Industrial Disputes Acts, then generally a workman is covered under this. However, if the workman purchase any item, becomes a consumer, then there is any grievances, there is any defect in the goods or deficient service rendered to him, then that person, despite being the workman covered under the Industrial Disputes Act and the Trade Union Act, he can have the remedy under the Consumer Protection Law for infringement of his rights under the Consumer Protection on account of purchase of goods or of the services. Apart from that, he can now give regular remedy as an employer under the industrial laws also. So these are so in short, in a nutshell, this is like a cooperative, a member of the cooperative society, consumer cooperative society, the best example. A member of the consumer cooperative society, he can remedy with regard to his rights of the members under the Cooperative Societies Act going to the cooperative court. But if the same consumer member of the cooperative society, he purchase some commodity from the same consumer store, then it becomes that, then if there is a defective goods is sold by the consumer cooperative society, then it will become the consumer related issue. The same member, despite being a member of the cooperative, consumer cooperative, he can have his remedy under the consumer protection law. That is why it is said that the consumer protection is in addition to the all other remedy available in the regular laws are concerned. So that is what the object, this is very, very important provision is concerned. Consequently, a consumer may still decide into proceedings in civil court under the Indian Contract Act or sale of goods even after coming into force of the Consumer Protection Act. Now, with this, we are coming to the main body of the Act is concerned, and now we already referred to the establishment of consumer protection councils. Now, as I said, that there was a three-tier mechanism. At the national level, it is called the Central Consumer Protection Authority. At the national level, it is the chairperson, the Union Minister of the Ministry of Consumer Affairs. He will be the chairperson. There are 36 other members who constituting that Consumer Protection Council, National Consumer Protection Council is concerned. Then again, it's the advisory body. They are only advisory nature. Their advices are not binding on the government is concerned. Similarly, at the state level, the State Consumer Protection Council are established for each state, and the chairperson of the state minister for consumer department, he will be the chairperson of the state level committee. Then again, the membership number of members are provided on the act is concerned. And the third tier at the district level, District Consumer Protection Council established at each district, and the district collector will be the chairperson of this committee, and they will meet regularly, maybe once in a month or twice in a month, or as required, as number of times as required by the body is concerned. So the meeting can be called up, but a minimum of one meeting at the national level, a minimum of 2 meetings at the state level, and a minimum of 3 meetings at the district level. Apart from that, they can call any number of meetings, any number of times, subject to the requirement is concerned. This is about the consumer protection. Their job is advisory nature. They can advise only in the policy related matters. Now we'll come back to the Central Consumer Protection Authority is concerned. It is as I said, it's an investigation wing. Their job is only to investigate on the complaints received from the member, from the consumers, or from any other person. The investigation, there are again, it's a three-tier structure. At the national level, there's a Central Consumer Protection Authority already established. It is housed in the Indian IAPA, Indian Institute of Public Health, New Delhi, and they have appointed the Director General, and Additional Director Generals have been appointed. The Additional Secretary in the Ministry of Consumer Affairs is appointed the Director General of this National Consumer Protection Authority. And there are 2 joint secretaries in the Ministry of Consumer Affairs. They have been appointed the Additional Director Generals of the National Consumer Protection Authorities. They started functioning, and their job is primarily to investigate on the complaint received, based on the complaint received, or suo moto, based on the information received through newspapers, media, and other social medias and all. They can initiate action by themselves. Likewise, one such example, there the National Consumer Protection, that they noticed that some complaints have been seen in the newspaper media that honey sold in the market is contaminated, it is not pure, it is adulterated and all. By seeing the news in the newspaper and this thing, the Protection Authority already suo moto took the decision, collected the sample and sent it for investigation purpose to find out whether honey sold in the market is whether pure or as per the standards prescribed by the regulatory authority, and also they have the suo moto power also to initiate action in the interest of large interest of the public is concerned. Then the second level is the commissioner of the, there is a second tier at the regional level. The nation is divided into several regional levels based on certain criteria. Maybe it may be east, south, north, west, north, east, and all, maybe whatever the criteria. But the regional officer, commissioner of regional officer created at the between the district level and the national level, and it is called the regional center is concerned. Again, a person ADG level or JD's level will be appointed there only. Again, at the district level, the investigation wing is created. There, the district collector, the chairperson of that district wing is concerned. Again, with regard to that council and the investigation wing, their functions are clearly demarcated. Their job is only to provide advice only. Here, their job is to carry out the investigation based on the complaint received or based on the any other suo moto complaint and all, then to carry out the investigation based on the complaint received. That is the function of the Central Consumer Protection Authority is concerned. We move to the third mechanism again. about the consumer dispute redressal mechanism is created at the district level, state level and the national level. Their primary job is to settle disputes between the consumer and the seller of the goods or the service provider and all. In the district level commission is, it is established by the state government. In each, the state government is vested with the power to establish one district commission in each district, and in cases where there is a district very large, the state government is vested with the power to establish more than one district commission also within the same district. That power is also given to the state government, and there will be the members. The composition is concerned, there will be one president and not less than 2 members at least, and not more than number of persons as per the law is concerned. Minimum one president and not less than 2 members. That's the minimum composition. And the state government is they, with the consult with the central government, they can enhance the numbers also. Then coming back to the jurisdiction of the district commission is concerned, then the jurisdiction about the territorial jurisdiction one. Then with respect to financial jurisdiction, any the goods or value of the goods and services, if it's less than 1 crore, then the district commission is the appropriate first forum to entertain the complaint. So for goods valued or the service values, if it's 1 crore or less than 1 crore, then the complaint has to be filed before the district consumer redressal commission only. Similarly, at the state level, again the state government is vested with the power to establish the state consumer dispute commissions only. In some cases, the state government generally they don't go for it, but in the central government, in the smaller state, like they have been vested with the power to constitute one state level commission for more than one state also, so northeastern states like smaller states and all. Again, the membership is concerned not less than 4, so there will be one president, then not less than 4 members. In the district forum, one president generally will be the judicial person, and other than them only 2 members in the district commission. In the state level of the state commission, this the member is increased from 2 to 4, and the president again he will be the judicial person, means either a person sitting judge of the High Court or the retired judge of the Supreme Court, a person qualified to be the judge of the High Court, he or she will be appointed as the chair president of the state commission. With respect to the district commission, a person sitting judge of the district court or person retired as the judge of the district court, a person qualified to be the judge of the district court, he or she can be appointed as the president only. So judicial member, these are the other than members. And the pecuniary financial jurisdiction of the state commission is concerned, if the value of the goods ranges between 1 crore to 10 crore, then we have to file the case before the state consumer redressal commission only, not at the district level, not at the national level also. This is about the state consumer dispute redressal is concerned. And the National Consumer Dispute Redressal Commission, again at the national level, the central government is vested with the power to establish the National Consumer Dispute Commission. In addition to this, the central government is also vested with the power to establish regional branches of the National Commission, like we have the benches of the High Courts and Supreme Court. Analogous to that, National Commission have its own regional benches at different places depending on the need and requirement, but the central government is vested with the power to appoint the National Commission as well as the benches of this commission is concerned. Then now we are again the composition, there will be the one president again the president will be either the sitting judge of the Supreme Court or retired judge of the Supreme Court, or a person qualified to be the judge of the Supreme Court. Generally the person qualified to be the judge means a person who has put in a minimum of 10 years in the practice in the concerned court. He or she is qualified to become the judge of the concerned court also. That's what a person qualified to be the judge of the Supreme Court or the High Court or the District Court, as the case may. In addition to this, not less than 4 members again, but the central government has the power to increase the number to any number depending upon the need is concerned. Coming back to territorial jurisdiction again, if the value of goods purchased or if the service hired is range beyond 10 crores, then the case has to be filed as the first instance before the National Commission only. Coming back to this, there are two types of jurisdiction. One is the original jurisdiction, another appellate jurisdiction or appellate jurisdiction. In the case of District Commission, there is no provision for the appellate jurisdiction. Appellate jurisdiction which means that when a competent court has given its decision or a verdict, and if the decision is not to the satisfaction of the aggrieved person, then the aggrieved person has the right to go on appeal or prefer an appeal against the judgment of the particular court, in this case district forum. So therefore, in the state commission will have the original jurisdiction up to 10 crores. In addition to that, the state commission will have the appellate jurisdiction over the decision given by the state commission also. Similarly, the national commission will have the original jurisdiction up to the value of 10 crores of goods purchased or services hired. In addition to that, they will have the jurisdiction to decide matters on the cases appeal received based on the decision given by the state commission also. This is about the composition, jurisdiction, and the constitution of the consumer commissions and all. We will move into the next aspect is concerned mediation. Mediation, again we have the separate lecture on video, you can watch that. Very briefly, mediation of process wherein a platform is created for the benefit of the aggrieved persons to come together in a common platform for the purpose of, say, ventilating their own views, grievances, and also that a common atmosphere is created, a conducive environment created for the parties come together, sit together and take a decision, arrive at a conclusion on the issue of the dispute is concerned. So it's a process where a person, third party, he will be sitting as an umpire between this complainant and the person against whom the complaint is made. They will be sitting and they give you in the presence of the mediator. The umpire is called the mediator. The advantages of mediation is like the problem faced with the consumers through the long delay before the court of law, waiting for a longer time, and the uncertainty over getting the timely decisions, all these things will be curtailed. So in the mediation process, the party agreeing on these issues, they can immediately say give it in writing to the mediator, then that will be given to the court, consumer court concerned, then immediately order will be passed based on the agreement reached by the parties concerned. So through the mediation process. Then the process, there are steps and all. The process involves first one, number one, if the parties agree on all the issues raised in the complaint, then the mediator has to prepare a complete report and success report and give it to the consumer commission for passing the order. Then second situation is where the parties may not agree, suppose on all the issues, they may partly agree on some of the issues, they partly disagree on some other issues. So in such cases, the mediator will prepare a part reports about he will list out issues on which agreement or consensus is reached and the issues on which the consensus have not been reached. This report he will submit to the concerned commission, and thereafter the commission will keep it aside the issues on which the consensus have been arrived. Then it will take only on those issues where the consensus have not been reached. Then the further proceeding initiate for the settlement of the dispute through through the commission's mechanism and all. So settlement through mediation means then based on the mediator's report, the court will pass an appropriate order recording the settlement. That is what we have talked about. Then we have the product liability. As I said, the law provided for initiating liability against the product manufacturer, service provider, and the product sellers. Exceptions are that we will not look into. Then coming to offences and penalties, the law provided for the penalty for non-compliance of the district or direction of the central authority, punishment for false or misleading advertisement, punishment for manufacturing for sale or storing or selling or distributing or importing of products containing adulterant, punishment for manufacturing for sale or storing, selling or distributing or importing spurious goods, or cognizance offence by the court also, then vexatious search and seizure and all made and all. So these are the type of major offence and penalty provisions. With this, we conclude this presentation on the salient features of the consumer protection concern. I'll request you please read the material provided by all carefully, and you may benefit out of this. Thank you very much for all of you, please. Thank you very much.